Welcome, everybody, to Legal Tech Week for May 20th, 2022. I am Bob Ambrogi. I am the moderator of this program, and I also write the blog Law Sites, which inexplicably you find at lawnext.com because we've changed all our URLs and it doesn't make any sense. But it will someday, promise me. I mean, trust me. And I also have the podcast called Law Next. Well, there you go. And our panelists today, as you see them, kick it off. Steve, you want to start us off?
Hi, Steve Embry, Louisville, Kentucky. I write the blog Tech Law Crossroads about legal technology, legal innovation, and various and sundry things. Greetings.
Greetings. And Niki.
My name is Niki Black. I am the legal technology evangelist at My Case Law Practice Management Software. I write about the intersection of law and tech at a few different publications, including ABA Journal, Above the Law, the Daily Record. I sometimes write blog posts for the My Case blog as well.
Thank you. And Joe.
Joe Patrice from Above the Law and the podcast Thinking Like a Lawyer. I'm in a little more rural area of New York, tending to my foxes, which is not really true, but I've got a fox outbreak here that I'm trying to control.
And you're referring to animals, we want to make clear.
No, good point. But yeah, no, in this case, I am referring to animals.
Yeah. And soon to be Bolivia bound, Zach Warren.
Soon to be Bolivia bound in a few days. Yeah. Hey, everybody. I'm Zach Warren. I'm editor-in-chief of ALM's Legal Tech News. You'll also see me on law.com and other ALM brands. I'm here pretty hard of the city, Minneapolis, but we've definitely had a turkey in our backyard before. There's wild turkeys in the Twin Cities, which is very interesting.
They're everywhere. They're in New York City now. Wild turkeys.
Yeah.
Taking over.
They are taking over.
Well, I only have two comments. You know, I think the foxes in your woods are saying there's a human outbreak here. And we have to do something about it because this is really a strange one. And when it comes to wild turkey, the only wild turkeys that I'm familiar with are the kind that you drink.
Yep. That's when you know that you're in Kentucky.
Yep.
That's right.
Yeah. All right. Well, lots to talk about this week, and well, let's start with what none of us put on our list this week. But since we were just talking about this ahead of time, which is that My Case made another acquisition, and I think several of us reported on this week, and Niki may have heard something about it. I don't know. She may know something about this, but. They acquired DocketWise, which is a software platform for immigration attorneys, and it's interesting. It's been really interesting to me, not to it kind of funny talking about it in front of Niki because she obviously works there, but. My case is in some ways has just gone through from an outsider's perspective, this transition this year, the last couple of years, in which it's gone from never having made an acquisition to making a number of acquisitions over the last year, to kind of always taking this approach of building everything and not acquiring anything, to starting to acquire these different products. And I think it's really interesting, and I think it's reflective of how the whole practice management space has become extremely vibrant and interesting in terms of what's going on there. It's a competitive space, but it's a space in which there have been a whole bunch of kind of smaller players, and now we're starting to see the space mature and consolidate in ways that's really interesting. And then I thought, the other thing that was interesting in particular about the acquisition of DocketWise, an immigration platform, is that just last month, Paradigm, another practice management company, acquired a immigration case management platform of its own. So there are parallels there, and I think that's probably also reflective of the importance of immigration practice right now, and of the fact that immigration practitioners have some unique needs, particularly in terms of like form generation, whatever, that aren't necessarily addressed by your kind of off the shelf software. So
yeah, that was what really stuck out to me. And Reese reported it for us too. And I think he had a paragraph at the end specifically about immigration law and the importance of automating, just because there's so many requests coming in. There's so much happening within that space right now that I think there is a little bit more of a willingness for immigration law practices, which are usually a little bit smaller, to really embrace this stuff and say, hey, we need to get on top of this right now, because otherwise it's just going to be crazy. So that's why I think you're seeing a lot of immigration law focused startups, but also it makes sense by me why a company like My Case is looking to get an immigration specific tool to really service that market.
Yeah. I was just going to say, when you get an immigration specific tool, you're also tending to get a really good document assembly, form generation, whatever you want to call it, tool as well, which is kind of comes with the territory. So, Niki, I'm sorry, were you going to say something?
Well, I was going to say that, like personal injury, immigration is one of those practice areas that does have some unique needs, and that's why we had a case per acquisition, and docket wise, it's because there's a functionality and there are sort of documents that are required that if you can automate those, and trying to build that into practice management software, you can only put so much into one product, right? And this just gives lawyers options and customization capabilities, and and some flexibility, and that's makes ultimately like the core product more useful to more lawyers. Yeah. I would argue. So
absolutely. While we're on the practice management topic, again, I don't think any of us had this on our list to talk about this week, but did anybody other than me write about this Clio thing this week? The Clio put out this offer. Basically, we're going to buy you out of your contract with our competitor, so that you'll move over to the Clio platform. I thought that was a really interesting move. I don't think I've seen anybody do that. I think somebody pointed out that maybe Case Text did it at some point or something similar with people's Westlaw contracts. But essentially, if you've got, I think, sort of less than 6 months or something left on your contract with a competitor and you want to move over, they will give you an equivalent amount of free subscription access to Clio.
Sounds like a cell phone provider to me.
That's exactly what I was thinking too.
Well, but their coverage is different. You're going to get those maps. Our signal is louder in Massachusetts. Anyway, all right. So that was an acquisition. While we're on that topic of acquisitions, this has also been a interesting year in terms of legal tech companies going public and having IPOs. And Zach, you guys had a story on kind of taking a look at how those are going.
Yeah, the financials. So over the past week, it was Legal Tech Public Financials Week, apparently, where late last week it was Intap and LegalZoom. Then earlier this week, Disco and KL Discovery both had theirs, now that all of those are public. So we just had a short post kind of diving into what the financials revealed. Pretty much across the board, it was a little bit what you'd expect, where all of them had higher revenues. All of them also posted net losses, which kind of makes sense. They're growing companies. They're reinvesting a lot right now, but just how much they're reinvesting in R&D is something that stood out to me. Disco reported between Q1 2021 and Q1 2022, their R&D costs rose something like 93%. LegalZoom was, I think, around 71%. Both Intap and KL Discovery were in the 40 to 50% range over the same time span as well. So just seeing how much, even over the course of a year, And I figure the pandemic probably plays a little part in that. But still, when you think back to 2021, most companies were up and going by that point. So I think it says something about, even across disparate as what LegalZoom's more B2C, Intapp with their professional services and back office, than the two discovery companies. But no matter what, pretty much everybody is heavily investing in R&D right now. And it's a little bit, I think, of the keeping up with the Joneses, because there is so much happening technology wise kind of across the board that no matter what type of company you are, you need to try and invest in technology to keep up.
Yeah.
Yeah, not too much to add. It's just something that I think it's interesting we actually get insight into this stuff now, because so many legal tech companies are privately held by VC companies, that it's just fun to be able to actually look at some of the financials.
No, I mean, this wave of public stuff is great. I'm going to check right now on the market, and oh my God, no.
Just buy Bitcoin. It's so much safer.
Yeah.
I think that what's interesting about it too is it's all legal tech, but they're from sort of different, they serve different markets or provide very different products. So it's interesting to see. I think that being able to look at those, I think it was 4 companies, and I mean, I haven't done it, but the work that the analysis that you did, it's interesting to kind of see the similarities and disparities across those different, I think the similarities even more so. Like, what are they all kind of doing as these larger companies that have IPO'd, that are in different sectors of the legal tech space? And to see similarities is probably a sign that it's sort of this trickle down effect across the industry. So I think that's a kind of a cool thing that you guys did, to kind of analyze all those together. So that's cool. I like that.
And I think what you said, Zach, about it, it's just really interesting to be able to peek behind the curtain here, because there's so many claims that we are all presented with from, marketers and PR people and whatever, or even just talking to CEOs about these companies, that you have no way of verifying in any way. I mean, again, just on the practice management area, I'll often get called. I get a lot of calls from analysts or other people asking, for my perceptions on things, and they'll always say, well, how many subscribers does this company have? And I don't know. I know I can tell you what they say or what they claim, but I have no idea really. And it, talk about my case. It was interesting because my case was previously owned by a public company, and my case was one of the few companies where you could actually go in and figure out exactly how many subscribers they had, because it was all reported on the public filings. So this is a good thing for us to have more transparency here into what's really going on behind the curtains in these businesses.
Especially as it
It's
relates to
certainly-
definitions too, right? Because different companies are going to define what's a subscriber or what's a user in different ways. But if in those public filings, there's a bit more of the definitions are agreed upon. There's like specific terms that are agreed upon. So I think it gives a little bit more consistency in that as well.
Yeah.
It really, I guess, reflects the maturing a bit of the industry, and it's nice now that legal tech startups can get access to this kind of information and sort of see what they have to, what kind of mountains there are to scale and what they're up against. And so I think it's a good thing all the way around, and that's one of the good byproducts of going public, I think.
Yep. I don't have any cool transitions here, so I'll just turn to Joe, because Joe, you had actually had a couple of interesting stories this week. We had several interesting stories, but a couple you wanted to talk about.
Yeah, a couple that vaguely touched on this subject. So I don't know what to do. You know what? Because Steve actually flagged this one for me. Let's talk about this. A few weeks ago, Sharon Nelson wrote a story for us at Above the Law about a series of data breaches, one of which was at a mid-sized firm, Stevens & Lee, which is, around 200 lawyers' offices, mostly in the Mid-Atlantic. And it had this data breach that they had worked out was around 300 people. were impacted by this data breach. Fast forward, and this week, Sharon's updated that story with the revelation that it's now up to around 23,000 people who were impacted by this data breach. And what it really drove home about this story for me was that, this is not, it's going to feel like this is a knock on the firm for not preparing for this, but it's, these things happen. You can only prepare so much. Hopefully you prepare enough, yada, yada, yada. I don't think there's like not paying attention here. Just, it's a thing that happens. But what I took away from the story is the lesson that there's no real cabining off of data breaches at this point. You think you can say, oh, well, only these got taken. Well, those included other information that led to these, Some of the letters that the firm is sending out is, you don't know who we are. However, your financial institution worked on a case that our financial institution was litigating, which meant that we got your stuff through discovery. And that's the whole issue, is that these breaches are bigger than people think. I don't think that firms are holding off on caring about this issue because they think it's no big deal. But I think the sheer scope of it might, push some folks to understanding that the upfront investment, where they might be tempted to say, well, we can get with the bare minimum, is probably not enough. And you probably should consider that even no matter how small you may think you are and how cabined off you may think you are, you can create a real big mess.
Well, it's it's interesting. I was on a panel discussion this past week with a judge, and we were talking about the threats to the judiciary and what that might portend in the cybersecurity arena. And they're real, because in addition to the fact that there are very private, sometimes, records that are part of public proceedings, not part of judicial proceedings, that are not public, but also the very real threat of ransomware and being able to shut a court system down, which could cause all sorts of chaos, both from the civil side and criminal side. And the judge that I was on the panel with was uneasy about the state of readiness of the judiciary, and so it's a very real threat. And the other point, of course, is that a lot of the very large firms, the AmLaw 100s, probably have reasonable security in place, but a lot of these very smaller firms, I'm afraid, do not. And this very example goes to show the mischief that they can be foisted upon them. Not to mention the fact that if they're shut down, they can't bill hours, then, oh my God. They're, in a very real sense, their real livelihood is at stake. So maybe this will be a catalyst to get everybody to think more about it. I hope so.
Yeah, that's exactly the point I was going to say too, is, if you're a bad actor, you're looking for that low-hanging fruit. The low-hanging fruit probably isn't going to be an AmLaw 100 firm that's invested so much in this and are actively looking for it. I don't think a lot of mid-size or small law firms see themselves as the low-hanging fruit, though. They think more, compared to some of those larger firms, we don't have as much data. The data that we have might not be as valuable, so we're not going to be the ones who are targeted. But that is absolutely the wrong way to think, because it's not necessarily about the value of the data. It's how easy is it for somebody to get in there? Can you get in, get out real quick? And in a lot of those cases, you can.
Yeah, and Michelle Spencer just shared the critical comment on this, which I don't care how sophisticated your security and data protection systems are. It really just takes one staffer somewhere in your firm clicking on the wrong link, especially in some of these ransomware attacks, to open you up to this. So it's really, so much depends on training, not necessarily sophisticated systems.
On cybersecurity panels I've been on in the past, where you've had a cybersecurity expert on the panel, one thing that they always talk about is that exact point, that it doesn't matter how strong the systems are. The weakest link is the employees. And clicking on this on a link somewhere. And once they click on that link, especially in the larger firms in particular, they will sit in there for a long time and just wait. You know, they'll track the systems, they'll wait for that big transaction that's going to occur. And, you know, they're not going after those small pickings. Either they're going to like lock up the whole system and like do a ransomware thing, or else they're going to wait until they can do that email spoofing and get in the middle of a large transaction and get the money sent somewhere else, you know, one of those wire transactions. So that's oftentimes what happens. And I've heard more than one person say on more than one occasion that oftentimes they'll, once they go in there, they see the bad actors been in the systems for like months, you know, waiting until they have that opportunity. That's the big opportunity. So it really does depend on the goals of that bad actor, but no matter how they get in there, once they're in there, they can do a lot of mischief and damage. And it's not great. It is unfortunately the times we live in. And ever since that Equifax breach, I feel like my stuff's just out there. Like, I don't even know what you can do about it. Like, it's all out there. I've given up. I may as well just tattoo my, you know, social security number on my forehead and call it a day. Like, it's all out there.
Yeah. Was it, Joe, do you know, was this a ransomware or was it a just...
I believe this was. That's my recollection. I was focused on the aftermath because she'd already written the story about it. But yeah, I think that is it. And yeah, like one takeaway I had, and I think I wrote about this during Legal Week. I in the bar, surprisingly. I was sitting there, and there was a representative of a cybersecurity company I didn't really know, and I've started chatting. And one of the things that he said that was very interesting was that, you know, remember Legal Week was mere days, about a week or so or a couple weeks into the Ukraine invasion. One of the things he said was, we're finally hearing from some of those firms that for a long time we thought we would call and they'd kind of blow us off like, oh, we don't really need to invest. And just the mere prospect and all the media reports of what Russia can do if it wanted to cyber retaliate had finally sunk in with some of these firms, which is an, you know, awful reason. But if that's a side effect of what's going on, that could be good for the future for cybersecurity.
Yeah. All right. Steve,
I'm here.
You're here. You're here. I'm not fully here, but you're here. That's good. What do you got this week, Steve?
Well, there was an interesting article that Brenda Jeffries for law.com wrote. Apparently there are 3 very large firms, Ropes and Gray, Cooley, and Goodwin Proctor, who have hired Texas lawyers, and it wasn't clear whether these are associates or partners or what have you. They've hired lawyers whose primary practice area is Texas, and yet they haven't opened any office in Texas. None of the 3 have. And you know, it made me start thinking whether this is maybe something we're going to see a lot more of, because we can. I mean, you can practice remotely. And if you wanted to test the waters in another state without investing in brick and mortar stand-up offices, you could easily do it. And that, you know, that has a lot of advantages. You know, I had a whole series of cases once upon a time in North Carolina, and we seriously considered opening an office in North Carolina because of the work that we had, all the work that we had there. But we didn't, and thank God we didn't, because, you know, the matters ultimately went away after a period of time. But that could be a lot easier to do now. And so I just wonder if we're going to see a whole lot more of that, because, I mean, frankly, of course, you know, my situation is a bit different because I was with a larger firm with more sophisticated clients, but I very rarely saw a client grace the door of my office. If they wanted to meet, it was like, you're coming to us, pal. We don't have time to go to you. So it was never really a very big issue with my clients about where I was or what geographically where I was. But as we see now with our technological capabilities, you know, you could establish a beachhead any place, and if it works, great. If it doesn't work, then your investment is, you know, relatively small. So I thought it was made a kind of an interesting point about where we may be headed as a profession, with particularly with some of the larger firms and maybe even smaller firms.
Yeah, and it fits with something we talked about here a few weeks ago, and I actually did my podcast on this just this week on this proposal to modify Rule 5.5 to allow a lawyer licensed in one state to represent clients in any state. And Joshua Lennon put a comment in the chat about no bona fide office rule in Texas, but if this 5.5 change were to come about, you wouldn't need an office anywhere. You could represent lawyers anywhere. I mean, represent clients anywhere in the country, no matter where you were licensed. Something again, I know we talked about this before, but something that I thought was interesting and came out in the I had on my podcast Brian Faunham, who's the president of APRIL, the Association of Professional Responsibility Lawyers, which is the group that called for this, and he feels like the chances of something like this happening with the ABA are pretty good. I mean, I think when we talked about it a few weeks ago, we kind of speculated that sort of an iceberg chance in hell of surviving or getting very far. But he said a couple of the people who drafted this report are actually members of the ABA Committee on Professional Responsibility, and one is in fact the chair. So he said, even apart from their request to APRIL to consider this issue, there are forces happening within the ABA that are pushing for the ABA to consider this. So this could actually happen. I mean, I'm sure it's a ways down the road, but be interesting to see.
The office in the cloud.
The office in the cloud.
My office is in the cloud.
Yeah. And we're going back to the simulation I see in the chat here. What I want to know is, if this is all a simulation, why am I not in the one where they're like simulating people being immensely rich and successful or something? Why am I in the other simulation?
They are simulating that. You just aren't in that.
I see.
You're pretty successful.
I'm seeing it.
You're not giving yourself enough credit. Come on, Bob. You're very successful. I don't know if you're rich. I haven't seen your
rich. I am not rich. I am not. No.
It reminds me of
trust me on that one.
It reminds me of the Bill Murray speech in Groundhog Day, where he says, I was on the beach in Jamaica having rum, and, having the time of my life. Why couldn't that be my day to repeat all the time?
Right. Yeah.
He said a few more things, but I won't go into that.
Yeah. Well, if we run out of things to talk about, we can go back to a recap of the highlights of Groundhog Day. So Niki, what do you got this week?
Well, I wrote an article about a topic that I like, the intersection of tech and criminal justice. And the article,
but none of us can read it because this behind
it's behind a paywall. Sometimes they get picked up by one of the sister publications, and it's not always behind a paywall, but that didn't happen this time. But I can share the link, and I can also share the case in the chat. It's what I really liked about it was twofold. This case was about let me get the link. The case was about a defendant who, in a trial that was remote, like an online trial, and the defendant got muted at some point. And so the case that was brought was an appeal. This is the case that it's based on. It included some assertions by the defendant that it violated some of his constitutional rights by muting him, and it was muting him during sentencing. And I really like this because some of my favorite legal tech cases or ethics opinions are ones where the judges try to take online conduct and compare it to offline conduct in order to come to an appropriate decision. And, we all know that online is it's the same, but it's different. But I think the best decisions come from that type of analogy, trying to figure out how is this equivalent to offline conduct. And in this case, there are a couple conclusions that the court came to, and I think the court reached the right decision. They first of all said that contrary to the defendant's assertions, it wasn't Sixth Amendment rights that were implicated when he was muted during his virtual sentencing, because muting is not akin to physical removal, meaning that he could still be there, he could still see what was happening. And so because he was not physically removed, it was more akin to a due process clause violation. So that analysis applied. And they turned to the assessment of whether muting him violated his Fifth Amendment right to due process, and concluded that that wasn't the case because the matters that were discussed when he were muted were sentencing factors, conditions of his release, and that type of thing. And muting didn't adversely affect his counsel's ability to urge a favorable sentence. And I think in part the thinking was that, typically defendants don't have a lot to say at that stage of sentencing. And then they finally said that his claim, then there was a second muting that occurred post-sentencing, but before the proceeding had concluded. And they said that didn't impact his right to a meaningful allocution because the court had afforded him 2 opportunities to speak prior to his actual sentence. So I just thought that it was, I just love those cases where something's happening online and things can be done. I mean, it's pretty difficult to mute a defendant in person. I guess you can gag them, they handcuff them sometimes, you can remove them, but muting someone is kind of difficult to do in a courtroom, but it's really easy, as we all have learned online. And some attorneys have complained about getting muted while they're making oral arguments, like they can't object or interject. And so I thought it was just interesting that the defendant was muted, and it resulted in this really being the linchpin of his appeal in terms of what his counsel was trying to argue for him. So I thought it was a really interesting case, which is why I wrote about it. And I really do enjoy those cases where for some reason I geek out when the courts are trying to do the online to the offline analogies. So this one pleased me and I liked writing about it.
This would be like what would happen if the trial of the Chicago 7 had been in the digital age. Bobby Seale sitting there gagged.
I'm wondering if there is down the road going to be some official rules of conduct or anything that some courts will adopt, because it seems like so much of this is a case-by-case basis right now, where Niki, as you're going through the facts of the case, it's very much, well, it happened at this specific time, so that's okay. This other specific time would not be okay. It seems like somebody just begging to formalize the entire process of this is when it's okay to mute people, this would be a due process violation. But I'm guessing probably not enough remote court cases that somebody's really taking the lead on that right now.
A really good thought. I hadn't even thought about that, but I think you're right that at some point they probably will just come to some sort of determination of the what you can and can't do during these proceedings in terms of muting and that type of thing. And that would make a lot of sense too. And that would just forego, I think it'd make it easier because you don't want the appellate courts to be flooded with appeals based on all these little minutia issues. If they can, nip that in the bud by coming up with these procedural issues, not issues, but procedural processes that will hopefully nip those in the bud. I mean, you can appeal the entire process if you want, but once you do that or a couple parts of it, then it's sort of, this is how it's done. So stop appealing on these little minutia things. So that's an interesting idea. I wonder if that'll happen.
And I don't know, we may be a ways away from where there'll be actual civil rules, but I could easily see, various courts imposing local rules to govern these kinds of things. And, that's probably a very good idea.
Yeah, I'm thinking back to, there must be something, I guess, I'm not sure if this is entirely analogous, but a few years ago, there was this experiment in Massachusetts with live streaming cases. This is pre-COVID, with live streaming all the cases coming out of Quincy District Court. It was run through some experiment with Harvard, and I forget exactly who else was behind it. But I remember at the time, they clearly had some very specific rules that they had developed around basically when the mics can be turned on and off, and in what circumstances, the live streaming could be, the cameras could be turned off, the mics could be turned off. not exactly the same thing to what you're saying, but they had kind of spelled that out. And I would think with some other, must be some other courts where they're where they're streaming or broadcasting trials that certainly have developed rules around at least some aspects of that. All right. Well, since Zach is not going to tout the news that came out of his company this week, law.com, maybe I will do that. Because, well, it has a news angle to it, right? I think it's an interesting development. This is some of the, I'm sure you've probably heard of this law.com radar, which kind of launched a couple of years ago now, I guess, as Legal Radar initially, then got rebranded as law.com radar, which is an interesting in and of itself, because it is a news service with stories essentially generated by algorithms, and essentially it's monitoring the federal court dockets and in some cases transactional data as well, M&A data, and creating summaries, news digest news summaries that you can then subscribe to and tailor to your practice area or the things you're interested in following, your state of practice or your client, or even follow your own firm. But so this week they rolled out in beta this new feature called trend detection, and it takes it a little bit farther in that it is now kind of taking this same data, but looking for patterns, looking for trends that could be newsworthy, effectively. Again, especially based on what a lawyer or legal professional's practice area might be, or what they're interested in following. But it might tell you that suddenly there was a surge in copyright cases in a particular district court, or a drop in class actions in a particular product area, or something like that. And it's intelligence that law firms in some cases are trying to compile on their own anyway. I mean, in some cases they are trying to detect exactly these kinds of patterns so they can figure out where maybe the next area of litigation might be, or how they might be wanting to shift their own forces internally or whatever else. And so this is doing it algorithmically, and it's kind of cool. They I've been kind of watching it for the week now, playing around a little bit, and it's cool in and of itself, and it's also cool to the extent it tells us something about where news is, where the business of news reporting is headed. Increasingly news is being reported algorithmically. Google News being one of the Google News isn't reporting it algorithmically so much as it's compiling it and generating it, but there are services out there that are reporting essentially like sports news and that kind of thing algorithmically as well. So pretty soon we will all be out of work. The robots are coming to take our jobs.
It's a different type of work. It's not out of work. No, I mean, not to shill for my own company too much, but I do think it's something cool that they're doing, and that is very much an editorial-led project that Vanessa Blum and Ben Hancock out of ALM's California offices are leading there. And I do think to a certain extent that is a little bit of the future of news. Like, I know my alma mater at Northwestern has invested heavily, actually, the Knight Lab for AI and journalism. That's the entire point, is how exactly can we use the knowledge that journalists have, but automate some of the processes. So not only is the news getting out quicker, but it's kind of like you say for AI and law, journalists can focus more on what they actually want to do, which is more investigative reporting, more digging deep into what actually matters versus just putting out newsers. So something like this, I mean, I told Vanessa explicitly, I love this and probably will use Radar more because of it, because tracking individual litigation pieces, not exactly it's not something I do on a daily basis, but tracking trends is very much up my alley. And I imagine it's very much up the alley of others too.
Yeah. And I told Vanessa explicitly, I want her job. She's got the best job.
I would think it would be of interest to, companies that have lots of litigation, like an insurance company who may want to know as quickly as they can whether the widget maker they insure is going to get hit with a series of lawsuits, so they can then exclude that product from their coverage.
Right. And she's also suggested that, at some point they hope to extend this to transactions, and then beyond that, extend it more into some of ALM's own data. And ALM collects a whole ton of data about law firms and legal practice that I'm sure they're already applying a lot of analytics against. But to be able to kind of start to apply some predictive technology to that as well could be really interesting. So,
yeah, I'm very concerned about the algorithm that's going to copy the way I write. Just like it's like court says, insert order, Simpsons reference, off-color joke, law. Are you serious? Some sort of profanity. Conclusion.
I now want somebody to build this.
It's so formulaic.
Is that the formula, right? Is that it?
I got like one of those forms. It's like Mad Libs, really.
Yeah. Steve, are you gonna say something?
No, I was gonna. No. I don't think so. I don't think I can say anything to top that.
All right. We had a couple more things on our list, but we can also give people back some time today if we want to head off for the weekend a little earlier. And I know Zach's got a whole lot of packing to do, so won't be here for the next couple of weeks. We'll miss you.
Yeah, have fun fleeing the law in Bolivia.
Somewhat. It's actually going to be a bit of a pain because the flight down there. So the reason I'm going is my wife is working with a medical nonprofit in the city of Cochabamba down there. She's been there for about a month. I'm meeting her for the end of her stay, and then we're just going to see the country for a bit. But to get to Cochabamba, Bolivia from Minneapolis may surprise you. There are no direct flights. Next Tuesday, I will be going from here to Houston, to Sao Paulo, to Santa Cruz, Bolivia, to Cochabamba, Bolivia. Fun times in travel ahead.
Awesome. Good. Get a good face.
Butch Cassidy and the Sundance Kid flee to Bolivia. Zach Warren and law.com fleeing to Bolivia. That'll be my story for next week.
That was definitely the movie I was thinking of, and I'm like, Zach and Reese are on the run.
Why did I immediately go to Che and you went to Butch Cassidy and the Sundance Kid? All right. Well, I will not be anywhere exotic next week, so that means I will be here, and I hope others of you will be here as well. And until then, I hope everybody has a good weekend and a good week, and see you then.
So long, everybody.
Bye, everybody.